do something before everybody comes in. You good to go? Everybody here that we need? Records should reflect the presence of Mr. Chrisman and counsel. The jurors are not yet present. The record should reflect that over the lunch break, the bicycle was examined, and based upon that, Mr. Martinez, what is it that you wish to do?
The state wishes to call Lucian Haig to testify.
For what purpose?
The defendant, it's a rebuttal purpose, number one, and then there's also a secondary purpose, which is the jury's question. With regard to the rebuttal purpose, the state does not know before the defendant testifies what it is that he's going to say. We all know that in terms of the constitutional protections, the state does not have an opportunity to interview the defendant. Our first opportunity to know the defendant's story or what he is actually going to tell the jury is when he actually tells the jury. And that's what happened in this particular case. There's a long line of precedent that indicates that in those circumstances, the state may call a rebuttal witness in a timely fashion. Yesterday was the day that he finished his cross-examination and his redirect, and is really the first day that we then knew exactly what it was that he was going to say and what it was that he said with regard to the bicycle. The demonstration was done the day before, I understand that, but he again continued that part of the testimony the next day. He could have changed his mind from one day to the next. So the first day that the state knew of the defendant's story involving the bicycle was yesterday. Today, we indicated actually yesterday that based on the defendant's statements, we would be seeking to perhaps call Mr. Haig to testify. It all was dependent on his schedule. His schedule did allow him to come in at noon today to examine the bicycle. And he reached his conclusions, whatever they are. Additionally, the jury has expressed an interest through, I believe, 2 jury questions, wanting to know whether or not the bicycle has been examined to determine whether or not it has any stippling or any gunshot residue. This is also to allow the jury, or to provide that information to the jury. Mr. Haig has been interviewed, and he was interviewed over the lunch hour after he completed his examination with all parties present.
And Ms. Martinez, based upon, I think, we had a brief discussion off the record, so I understand there's going to be an objection. So
yes,
for me to rule on the objection, what were Mr. Haig's findings and what opinion has he drawn from it?
He will indicate that he did not find any, it's two-pronged, he will indicate that he did not find any evidence of bullet damage. That's one of the particles that could have gone through. And he will also indicate that he did not find any evidence of any stippling of any, which
Lewinsky interviewed Rich Chrisman at length as to what happened, and a complete narrative of what his version of what happened that day. Mr. Martinez interviewed Dr. Lewinsky in November 2011 and knew then that. But putting that aside, and just saying, well, that was that. On October 5th, 2010, they knew exactly what Rich Chrisman said because, and I'd like Mr. Gann to read you from Mark Kincannon. I think you heard this morning that Mark Kincannon, one of the officers in the scene, Mark Kincannon's VR police report, which was authored shortly after October 5th, 2010, says this.
Officer Chrisman said the deceased began fighting. During this fight, the deceased was tased twice and pepper spray was utilized. Officer Chrisman said during the fight, the deceased was trying to grab his service weapon and trying to throw his bicycle at him. Officer Chrisman said he had to shoot the deceased.
They've known since then that the bicycle was involved, yet they didn't do any tests for gunshot residue for over 2.5 years. And now they come in and say, we are shocked to find gambling going on, as Casablanca said. It just seems that, as they said, I conducted my 4th interview of Mr. Haig this year, even though he was hired in December of 2011. We weren't even told of what he did in 2011 until over 2 years. And this is one more instance of this trial by ambush. A visual inspection, we were there, watched him look this bike over, and then we were afforded a chance to interview him, and we did during the lunch hour, and now they want to call him to give yet a fourth expert opinion to this jury. Judge, this puts less than this is not something that came as a surprise to Mr. Martinez. He's known since 2010 what Mr. Chrisman told his fellow officers, and Mark Buchanan was just one.
Mr. Martinez, you're the proponent, you get the last word.
It's clear that what the defendant told somebody else is not the same as my ability to speak with the defendant. The defendant invoked at the time. He did provide a jury statement that I have not been privy to, have not seen. So make the argument that says, well, I spoke, or he spoke to one of the other officers, and he gave the story to the other officers, would be akin to saying, well, all of the witnesses I spoke to, for example, Detective Porter, you can speak to Detective Porter about what those witnesses said. That they can say that that's what he told these officers, but I have no idea as to how he's going to describe it, how he's going to hold the bicycle up, how he's going to do anything until I actually hear it from his lips to my ears, and I think that that's what the rules contemplate. If he thought this was going to be an issue, he certainly could have afforded me the opportunity to speak with the defendant prior to this, and we would not have been here.
The court finds that there were jury questions regarding the bike. There was clear testimony during the state's case in chief about some swabbing of the bicycle, and there was some testimony regarding that. 15.1 and 15.7 contemplate expert reports being provided in advance of trial. So I don't find bad faith on the part of the state, but it is untimely. Everything that concerns me, through no fault of anyone and through good faith practice of both parties, this bicycle has been veiled, unveiled, bounced around through the course of the trial. So whatever particles may have been on it, if any, from 10.5, the fact that they're not there now, I believe under 403, is an unfair prejudice. I think it would have been more relevant there had there been particles than not in the circumstances of it being properly handled by both lawyers during the course of the trial. So for that reason, the court would, even recognizing it was a jury question, not answer the jury question and preclude Mr. Haig from testifying that he examined the bike today and his conclusions of his findings today. Under 402, 15.7, and 403.
The only thing that I would note is that Dr. DeMille did not provide any report to the state, and neither did Lon Bartel. That is a part of the court's basis for its decision. I understand your decision, I just want to make it right.
Okay. Anything else before the jurors come in?
No.
Mr. Meritz. Remember that. Yes, ma'am.
Oral here now, you ready?
Yes, ma'am.
Jury's coming in.
Okay. Needed records reflect the presence of Mr. Chrisman, counsel, and the jurors. Good afternoon. Mr. Martinez, how do you wish to proceed? Ladies and gentlemen, all the evidence that will be presented has been presented. I was told to talk into the microphone, so I'll move the microphone. While you have heard all of the evidence, you have not been given the instructions or the arguments of counsel. Just as you saw when there's a jury question, the lawyers get a chance to look at that. That same process happens for the jury instructions. So before they've been given to you, they have to be reviewed with the lawyers. And we couldn't finish them until we finished the evidence. So we're going to do that, and then we'll have the copies made. So we'll have the instructions and closing arguments for you on Monday at 10:30. Because you have not heard all of the trial yet, continue to keep an open mind. Don't discuss the case. Avoid any coverage about the case. Don't do any homework about the case. We've gotten you this far. Stay healthy. We'll see you Monday at 10:30. Jurors are excused. Anything for the record for now, Mr. Martinez? Mr. Marins? Well, before I adjourn, I'll set 1 o'clock tomorrow for argument on the instructions. I would ask counsel if they could email me. In the meantime, I can give you guys drafts as we go along so that when we come in at 1 o'clock, hopefully it's at least a final draft to work off the record. Anything else, Mr. Martinez? Sorry. Mr. Marins? All right. See you tomorrow at 1. Just logistics. Are you gonna do the closing? Are you gonna do your closing?
Yes.
I mean, set up. I'm just trying to think of a timetable. We'll excuse the jurors